I need help. I moved out 31st of June, got a quotation. I'm guessing from the landlord, and they say that I owe 12,000 Rand in repairs, but it's impossible because we fixed everything and even used one of their workers to revamp the place. And something wasn't fixed. If something wasn't fixed, I've got proof. Can they blacklist us for repairs? We don't agree that we don't agree to. And can they debit my account even though the lease is over? What can I do? Is the rental housing tribunal going to help me mediate the situation? So for starters, remember that a landlord is entitled to claim repairs from the tenant, right? Because the tenant's responsibility is to leave the property in the condition in which they found it, very often fair wear and tear excluded. So if it required repairs, a landlord is entitled to claim it. Very often they can claim it from the deposit. So this goes into that first question that we had regarding the water. That's why the deposit's there, right? But the Rental Housing Act does have very specific ways in which this has to be done. So there has to be actual costs incurred. It needs to be done within a certain period of time. The tenant needs to be informed, all of that. So this is just a general kind of answer to very similar problems that we experience. Now, in this specific instance, there were repairs, but the tenant is querying the veracity or the existence of those repairs, right? Now, that happens very often because people have different perceptions on how a place should look like when they leave. A landlord expects it to look better than when the tenant moved in, and the tenant exactly quite the opposite. The tenant remembers it very differently from when you moved in. So we do have that sense of perception. You know what works really well to avoid or at least supplement or help with this is the entry and exit inspections, right? And I don't think we can emphasize how important these are, because the one thing that doesn't lie, photos, lists of every broken tile, right? Entry inspections. It's not a list of things the landlord has to necessarily fix. So landlord shouldn't be petrified of this. It's just a list going, listen, when I moved in, there were 7 broken tiles. When I left, there were 7 broken tiles. So guess what? I'm not going to fix any tiles because there's 7, right? When I moved in, this window was cracked. Don't fix it. A little crack, don't really care. But when I moved out, same window was cracked, don't charge me for it, right? So I think that's key to this, for starters, is if you've got those inspection reports with pictures and lists and stuff like that, you should be good, because it's proved that when you moved in, it looked a certain way. When you moved out, it looked a certain way. So no one can complain, right? And with that, Rental Housing Tribunal will obviously help you. Now, if you don't have those exit and entry and exit reports, now it becomes a question of proof, and it becomes a question of oral evidence. It becomes a question of you pulling whatever photos from the time you were there and you just moved in, but it was friendly photos where you're having a party, and now you're trying to pull these photos to show that the window was in fact broken. If you look over your friend's right shoulder and there's a little window with a crack, but you can imagine how difficult it is. So will the Rental Housing Tribunal help? Of course, but your case is only as good as the evidence that you're able to provide. Same with landlord. And I think I'll leave this part for you, Nick, but like the Rental Housing Act does have specific requirements on how the inspections are done that almost kind of shifts the onuses on the people that fail to act. Do you want to maybe touch on that?
Yeah. So I'm glad we've emphasized, and I'm going to do it again, because really, I mean, inspections are just the most important thing. So you've got to do these things at the start and finish, no matter what. Okay. Once the lease has come to an end, okay, the Rental Housing Act is going to, well, even at the start, the Rental Housing Act requires the parties to come together and do an inspection of the premises, and then again at the end. Okay. And what's important in this particular case, I'm going to talk about the tenants, because Precious is obviously a tenant in the circumstances. But the landlord's got an obligation to get you in for an exit inspection. If you don't attend to that, okay, the Rent Housing Act has certain provisions that deem that you are happy with, okay, or you're not going to come, and the landlord can go ahead and do the inspection by themselves. Okay, so the landlord can then go and do it, and at that point, okay, you're going to have problems because the landlord is then going to look at the premises and they're going to figure out what needs to be done in the circumstances, and you don't have your say as a tenant in the circumstances. So really, it's important that the landlord's got an obligation, and both parties should really, in terms of the act, really have to come together for exit inspections and entry inspections to make sure that we don't have the issues that Bruno is talking about, where we're pitching up. These are things we experience in court a lot. The tribunal will deal with these particular issues as well. But I mean, fights over little things that you're using very, very outside evidence to try and establish what exactly goes on, and really it's a very difficult fight that doesn't really get anyone very far at the end of the day. So it's really important to make sure that you do these things, and make sure that you go to these inspections. The Rental Housing Act does provide for how to, certain provisions for how to do it. A lot of the lease agreements that are entered into between parties will also have provisions which may rectify that or amend it just a little bit. And it's really important to just. So I just want to reiterate, the Rental Housing Tribunal will absolutely help you in the circumstances. With regards to the blacklisting, look, in a circumstance like this, it seems to me if they're going to try blacklist you, they're going to need some level of judgment against you in the circumstances for a blacklist to occur. It's not like a recurring account or anything like that. This is just a debt which is owing. So I don't think a blacklisting is necessarily possible in the circumstances unless they're going to send you a formal demand and start a legal process. So that doesn't seem likely to me. And then the last thing is you mentioned a debit order in the circumstances. Now, I'm assuming in that case that there was a debit order on the particular lease agreement. Okay. And if that is the case, there may well be a debit order on these particular charges. So you need to address that debit order in the circumstances because the lease has come to an end. And if that's already occurred, then that's again a tribunal issue which they will be able to deal with fairly effectively. It's because it's a 12,000 Rand debt. It's one of those things that I'd be cautious before you run to an attorney too quickly. It's one of those things, by the time you get to an actual hearing before a magistrate judge, you're likely going to have spend more in legal costs than actually recuperating. So the tribunal is a very good medium in which to address this particular issue.
Sure. Just the last one. I don't know if through a bad connection you mentioned this and I missed it. Debit order. The debit order, you can go to the bank and stop the debit order. So if they haven't done it, stop it now, especially if you truly feel that you don't owe the money. Cancelling some debit orders do comprise breaches of agreements and things like that under certain circumstances. You're not actually allowed to do it. Yeah, there's a dispute resolution process in the agreements, especially with commercial leases and stuff like that. But in your case, it's doubtful. You need to check your lease, but it's doubtful. So if you don't owe the money, you can go to the bank and say, please don't allow any payment to go across the line for this. If they want to, they can sue, or they can take me to the tribunal and I'll defend. And remember, so it really happens. So more often than not, because a landlord has the deposit in hand, the tenant is on the back foot because it's trying to receive money back. Now, if there's no deposit in play or anything like that, now it's the landlord that's actively collecting. So you as a tenant just need to kind of build up your defenses and sit tight and wait. And that's typically the advice you get from a practitioner is there's nothing proactive you need to do except respond and go, listen, I deny. I did do this. I've got evidence proving it. I'm happy to get around the table with you, but I'm not paying you. And I deny being liable. And that's probably where I would go, if I was you.
Yeah, absolutely agree.